So, folks, one of the issues that we deal with is that we talk about parenting plans, but we don't have a clear indication in the legislation of what a parenting plan is. Fortunately, the Act does come to our aid, not necessarily so much in the form of a definition, but we do get some hints from the legislation on what is a parenting plan. And really, when you want to go down to the core of parenting plans in terms of the Children's Act, you have to go to section 33, 34, and 35 of the Act. Now, just to simplify things, and this is not a perfect distinction, but think of section 33 as the substance of your parenting plan, while section 34 really deals with the formalities. Things such as format, what do you need to do if you want to make a parenting plan in order of court and or register it with the Office of the Family Advocate. Section 33, as well as dealing with the contents of parenting plans, deals with the scenarios which may lead to a parenting plan being entered into, and that's section 33.1 and section 33.2, which makes the distinction between a set of holders of parental responsibilities and rights who enter into the parenting plan in circumstances where there is no dispute, that is the 33.1 parenting plan, and then the 33.2 parenting plan generally arises where there is a dispute and all the parties are having difficulties in exercising their respective parental responsibilities and rights. When one takes that further, in terms of section 34, some separate formalities apply to either the section 33.1 or the 33.2 parenting plan. That, however, folks, is not really the focus of today's webinar. What I would like to look at is what is a parenting plan and how do we deal with parenting plans. In terms of legislation, we really need to turn to these two sections, sections 33 and 34 of the Children's Act. Now, let's start with section 33. And section 33 gives us a little bit of an indication of what can be dealt with in a parenting plan, and that's under section 33.3. A parenting plan may determine any matter in connection with parental responsibilities and rights, including where and with whom the child is to live, contact between the child and any other parties, or any other person, and then D's spacing is not nice on my slide there, the schooling and religious upbringing of the child. So section 33.3 gives us really 4 scenarios, but it is quite deceptive, ladies and gentlemen, for the simple reason that we have a very, very broad rider introductory paragraph. A parenting plan may determine any matter in connection with parental responsibilities and rights. Now, this includes various things. It includes where and with whom the child is going to live. Now, just a reminder, folks, we always talk about primary residence. Primary residence, incidentally, is not a term that is accepted in the Children's Act, or it's not defined in the Children's Act. It's come into our law by means of common parlance, just because it is a descriptive term which really makes it easier to get the idea across. So for that reason, subsection A of section 33.3 does not say primary residence. It really deals with 2 separate things: where the child is going to live and with whom the child is going to live. These are 2 separate concepts. That's incredibly important, because if we just lump it together as primary residence, we lose half the picture, or we're tempted to lose half the picture. And it is incredibly dangerous, obviously, to discard the where in favor of the whom or vice versa. Then obviously we deal with the maintenance of the child. We deal with contact between the child and any other parties. Now, what is very, very interesting to me in terms of section 33.3, which I had to be reminded of as I was preparing this webinar, is that we can also regulate contact between the child and any other person. We can talk about grandparents, we can talk about cousins, aunts, uncles, but it is not simply limited to that. The Act is very broad in that it says any other person. Any other person could be a friend, it could be a distant relative, it could be an employee of one of the parties, if you really, really want to go broad. But understand that contact is not something that is simply regulated between our holders of parental responsibilities and rights. Don't forget that you can also deal with any other person. And then D, I found extremely interesting because A, B, and C, we could very broadly categorize into the frameworks of parental responsibilities and rights. Where and with whom the child is to live falls in with the concept of care. Maintenance of the child falls in with the concept of maintenance. And C, contact between the child and any other parties, deals with the concept of care. Guardianship, very interestingly, omitted, but I'm getting ahead of myself. That's another slide that we're going to go through. But schooling and religious upbringing don't necessarily fall into the categories of any of the parental responsibilities and rights as we know them in terms of section 18. I think specifically the legislator decided to put it in because these are really contentious issues. These are issues that we fight quite a lot about in practice, where one party enrolls the child at a particular school, other party wishes to enroll the child at another school, and the same with the religious upbringing. Now, very importantly, guys, in my interpretation, and I have no doubt in the interpretation of the courts and the family advocate, one is not limited to just these four factors. It says including, but it also says any matter in connection with the parental responsibilities and rights. And a practical example of that, folks, I see most of us are people in active practice, is the issue of guardianship. I have yet to see a parenting plan that does not deal with the issue of guardianship. The parties will both be co-holders of guardianship, or there will be a termination of one party's guardianship, obviously with the Section 28 factors having been dealt with. But if this section was exhaustive and one was limited to A, B, C, and D of subsection 3, I doubt that any parenting plans with guardianship or in terms of guardianship would go very far in terms of the various family advocates offices and or the court. So that is the contents of parenting plans, folks, in a very, very brief nutshell. Now, what I would like to do, if I can just silence my incoming WhatsApp call, I'd like to go into section 33.4, which deals with the formalities. A parenting plan, and this is from section 34, a parenting plan A must be in writing and signed by the parties to the agreement. Very, very interesting. Here the Children's Act refers to it as an agreement. And subject to subsection 2, which is some formal requirements, may be registered with a family advocate or made an order of court. Interesting, ladies and gentlemen, if we look at it, the usage of the permissory may and not the peremptory must. But that is a debate for another day. I'm not opening that can of worms today. This is section 34.1. Now, I would be failing in my duties as a presenter today if I did not take the provisions of section 34.1 and section 33.3 and try at least to thumbsuck a definition. And that is exactly what I've done. I have thumbsucked my own definition, which I'm going to share with you folks shortly. Please do not go and argue this in the High Court or the Constitutional Court. It is not case law. It is not based on any of the old writers. It is something that emanated in my dubious and convoluted and noisy mind. But I do believe that there is benefit to us to have a loose definition to solidify these concepts without always having to refer back to the Act. And the definition that I came up with is the following. A parenting plan is a written document signed by co-holders of parental responsibilities and rights in respect of a child, wherein the exercise of their respective parental responsibilities and rights in respect of that child is determined, which shall include any matter in connection with parental responsibilities and rights, but specifically residence, maintenance, contact with the parties, contact with any other person, schooling, and religious upbringing. So let's talk about contents of parenting plans, folks. Let's go a little bit further from what we said in the first session. And this is the first pitfall, ladies and gentlemen, that I want to highlight to you. And it actually comes from something that's really been on my mind. Someone on the WhatsApp group posted about a week ago that a family advocate queried their parenting plan and said they must put in standard contact. And the question was, what the heck is standard contact? And I want you to remember, whether you're an attorney or a mediator or a mental health practitioner, families are not formulaic. What is a normal family? What is a normal family unit? Certainly, folks, we do get certain regimes which are a bit more prevalent than others. Every second weekend, half of each long holiday, etc., etc. However, let's try not to reduce families to formulas. And that takes me to our next issue, which is once again section 33.3. But I want to really zoom in on this issue, that a parenting plan can look at any matter in connection with parental responsibilities and rights. It is not just a pro forma document. What is your requirement in terms of a parenting plan? We know that the Children's Act does not give us a standard template. I know there are lots of templates floating around. I know there are lots of institutions that say you must use their template or else. Those institutions shall remain nameless for obvious reasons. But we know that legislation does not give us a template. It gives us a few clues of what we must deal with. And I would go so far as to say, at the very least, deal with your 33.3 A to D factors. My D, once again, has been displaced in my slide. I apologize for that. But do not limit yourself to that. Understand that there is no standard template, apart from the fact that a parenting plan must be in writing, it must be signed by the co-holders of parental responsibilities and rights. Really, your only yardstick or measure in terms of whether a parenting plan is valid or a parenting plan is good or not is it must comply with the best interests of the child standard, as set out in section 7. And that is prescribed by section 33.4 of the Children's Act. And obviously, we know from experience, when we lodge documents for endorsement with the Office of the Family Advocate, what is their endorsement if they are happy with it at the end of the day, that they are satisfied that the document is in the best interests of the minor children involved. So I do want to encourage you to work with, shall we say, courage when doing parenting plans. Understand that you are limited by, apart from your imagination and the needs of the parties, your two yardsticks really are the following. A parenting plan must concern parental responsibilities and rights. Probably not appropriate to deal with issues such as spousal maintenance or division of assets in a parenting plan, although I know that it is something that one sees from time to time. And then number two, best interest of the child must be paramount, obviously. Now earlier we spoke about the issue of what about care and guardianship. Once again, my view, folks, is that that is covered under the moniker of any matter, and I've put that NB down there. So what I'm going to do now, with all of your permission, is I'm going to hand over to my dear friend Adell-Mari Wolmarans, who's going to be talking to us about child participation, the real interesting section of today's presentation. Adell-Mari, I'm going to spotlight you whilst I introduce you. Folks, Adell-Mari Wolmarans is a social worker in private practice. She will soon have her master's degree once she gets time to finish her thesis. She might kill me for saying this. She specializes in child participation in mediation matters, and she is also a mediator. So on that note, Adell-Mari, if I can hand over to you, and I will open up on your slide with your relevant legislation. Just unmute yourself, please.
I just need to underline that the practice that I have is a forensic social work practice. So we do specialize in all sorts of assessments and forensic work. For today, we're speaking child participation, and then everybody tells me or asks me, what is the difference between child participation and voice of the child? And it's actually the same thing. But if we want to be clinical around the terminology, if we look at Section 10 of the Children's Act, it speaks to child participation. So I believe how the voice of the child came into play is that when we started many years ago, when the Children's Act was promulgated, we still call it the New Children's Act, although I think it's almost older than the old one. There was a tool that was introduced by some of our colleagues, which is a wonderful tool. It's called the Voice of the Child Toolkit, and we can use some of those tools when we do a child participation assessment. And that toolkit was also then used by the Family Advocate's Office. And I believe that there's the basis where the word voice of the child came into play when speaking about the Section 10 child participation assessment. So what does it mean? In essence, if we look at the child, it means that a child is being included in decision-making processes. Okay? When we involve these children, okay, because now we're talking about the involvement of children. When we involve the children, their involvement can potentially influence the outcome of the decisions of the parents. But we do that without burdening the children to choose sides, or for that matter, needing to make the final decision. So when we look at it in a more safe space, because that sounds, I mean, do we really involve children? Yes, it's actually mandatory that children's voices are heard during these processes. They need to be included, and their involvement may potentially influence the outcome. So what do we actually say? We are providing the parents with information when we do a child participation assessment that can help them and assist them to make informed decisions in all family matters. So we're talking about divorce today, But child participation can be utilized in all family matters. So the benefits of child participation to children is that they feel heard, they feel empowered, and they can actually adapt easier to the changes in the family systems that comes from a divorce process. If we don't involve them, literature says that children may feel rejected, marginalized, and frustrated. The benefits of child participation for the adults and the processes that we are involved in family law is that it helps the parents to form an understanding of the perspectives of their children. They feel that the well-being of the children are also looked after because the children are involved and included. And it can lead to better communication between the parties, reduce their conflict, and then also get them to provide a safe emotional base for our children. And this is where we want to get into. So who can do child participation? Okay, so in all essence, a magistrate or judge can do a child participation. They can have an interview with a child. The legal representative of a child can have an interview with a child. And then a suitably qualified person can also facilitate a child participation. Suitably qualified in this instance can mean that you have a mental health background, psychology, social work, or therapeutic background, and you have to be adequately trained to be able to assess children. And feedback should usually be done in person. So when we ask for child participation assessments, we don't issue reports, because if we look at the reason why we're doing it, is we want to provide parties with information so that they can make informed decisions. A report can be interpreted by many people in different ways, and we don't want a document adding fuel to the fire. We want to have a process where clients and their legal representatives or mediators can sit in a room, they can receive feedback, obtain insight, and then ask questions. So the process can add to those already, the processes that the parties are, so that the child participation processes can add to the legal processes that the parties are already involved in. It can be used in all family matters. It doesn't necessarily just need to be in divorce matters. There's other matters that a child participation assessment can be utilized. But we must remember that child participation is really just the basic of all assessments of children out there. And no recommendations on primary residency can be made. If parties or legal representatives need a process where an independent person have to do an investigation to get to a place of recommendation of residency, we call that a forensic care and contact investigation. In between the forensic care and contact investigation and child participation, there is another assessment that is called a social emotional assessment. Within that assessment, we can start looking at hypotheses and dynamics in family systems and provide more thorough recommendations around the child's emotional functioning. I also just must state, remember that my background is that of a social worker, and these terminologies and of these types of assessments is based on our scope of practice. Psychologists also has similar assessments that they do. They sometimes just call it something else. And then, of course, they also do standardized testings that social workers doesn't do. We focus more on the dynamics within systems. Child participation, in essence, is for me to become the child's voice and provide the parents and legal representatives the views and wishes of the child. And that is, in short, what it's all about. I'm very passionate about child participation because it can really change the way that matters are proceeding. And being an old social worker in the olden days where children weren't brought into, or the views weren't brought into these circumstances, I was privy to seeing how relationships were broken down and not enhanced, and enhanced like it can be today. And that in essence, I hope you can hear me now, Mervyn. That in essence is this short presentation that we spoke about, just to give some background, some introduction to what child participation is and the different levels of assessment of children out there. And hopefully we have a few minutes for some questions around this aspect and the aspects that you spoke about.